to hear these cases. And that has happened for 3 years. I've been commenting upon it. I know that the Director of Public Prosecutions intervention was sought, and the DPP wrote to the Chancellor to assign a magistrate trial to prove the state has had to endure. Now we are where we are. The state is entitled to justice under our criminal justice system. The state represents the public interest. These cases are of grave public importance. They are cases of national importance. The conduct of the persons who have been charged and who are before the courts struck at the very foundation of the democratic process of this country. That conduct attempted to alter the will of the people as expressed by their ballots. That conduct sought to derail the democratic elections of this country. It sought to have a different government in place instead of one elected by the people. I say that to remind you that these are not ordinary run-of-the-mill cases. In any other democracy, the judiciary would have accorded the highest priority to cases of this type. Unfortunately, in Guyana, that is not the position. The judiciary must act and act quickly to reprieve its credibility in this matter. And I have to be frank. What is transpiring here cannot accord with the principles of justice understood by the ordinary reasonable man. Every Guyanese should be concerned with this state of affairs. And the duty lies with the judiciary to arrest this situation and to do so with every convenient speed. Public commentary on these matters cannot be stifled. This is a matter of the greatest public importance. We are going to another election, and we don't have a determination yet of fraud charges arising out of an elections that occurred 4 years ago. The Caribbean Court of Justice, our highest court, has repeatedly exhorted the lower courts in Guyana to ensure that matters of this type, matters which concerns electoral issues, matters that affect the constitution of a government, matters that affect the democratic and constitutional processes of the country, must be ventilated with speed through the system. This case, or these cases, tell a tragic tale. And I will leave it there for the time being. You will note I am not attacking the judiciary. I am the Attorney General and Minister of Legal Affairs with responsibility for the justice system. It is my duty and part of my portfolio responsibility to speak out on these matters, even if I have to make outspoken comments. I do so, however, respectfully, and I do so without attributing any ill or ulterior motives to members of the judiciary. I am choosing my language very carefully because there's a group of people out there who are ready to jump down my throat to say that I am attacking the judiciary. I am doing no such thing. I am making fair, critical commentary, which I believe is deserving on a very tragic state of affairs on a matter of national importance. So I finish with that and we'll move on. Continue to share the program, share the live, so that your friends and your followers can join us in tonight's discussion. Viewers would have read in the newspapers and elsewhere and would have known even 2 years ago that government is acquiring private properties to facilitate the construction of a new river bridge across the Demerara River. There's a project of transformational importance. Every single Guyanese will benefit from such a facility. No one can question the value. Let me rephrase that. No sane person can question the value of that project to the public good. We made it extremely clear that it's a time-bound process, that this bridge is funded from a loan arrangement with the China Exim Bank, and that the contractor must get vacant possession of the approaches to the bridge within a stipulated period. It is not the first time that we are doing compulsory acquisition in this country. We have done it repeatedly. We engaged these private property owners since 2002. We have had numerous engagements with them. Myself, Bishop 𝘕𝘓𝘕𝘓, Minister of Public Works, Colin Crowell, Minister of Housing and Water, Susan Rodriguez, Minister within that ministry, 𝘱𝑜𝑟wyn Chief Executive Officer of the Central Government officials. We sat with these people on numerous occasions. There were about 50 properties involved. We advised them to take their own lawyers. We embark upon a very transparent process of securing valuations from the government valuation department. We added to that valuation of their property a dislocation cost to move them. We offer them land or land and house, brand new, from Central Housing and Planning Authority. We offer them commercial lands in cases where they wanted commercial lands. And that's in addition to compensation that we are paying in cash. Most of these persons agreed. But a few, represented by politician lawyers, have refused and are demanding from the government compensation many times more than what the market value suggests. And that is where we have been. Now, the state took title for all these properties several months ago. You see, let me explain to you the law. In almost every country in the British Commonwealth and the United States of America and Canada, you have a concept called eminent domain, whereby the state has a power to compulsorily acquire property for public purposes, for developmental projects, and to pay the owner compensation. It is something that is embedded in the law. You own your property by title, subject to an overriding power of the state to take that property and pay you compensation. That is the law. Now, this law is not new in Guyana, and this law was abused by the PNC in years ago. So under 𝘱𝑜𝑚's regime, hundreds of properties, private properties, were acquired in this country. Not for public purpose, if you were politically opposed to 𝘱𝑜𝑚. That was one of the weapons in his armory. He used to seize your property. And the law then compelled the government not to pay market value, but to pay a 1939 value. That is what the law was then, under 𝘱𝑜𝑚, under the PNC. So the PNC took your property, they took Hope Estate, they took Tacoma Lodge, they took many properties, dozens, hundreds of properties across this country. Never used them for any public purpose. Never used them for the purpose for which they were acquired. They had some other agenda. And paid the people peppercorn compensation, because the law fixed compensation at a 1939 value. It is the People's Progressive Party government that changed that. And we inserted in the law that you must pay current market value. A lot of people don't know that. Please put that, make a note of that. It is the PPP government that removed that draconian provision in the law that pegged value for these properties at a 1939 valuation, and we inserted current market value. The People's Progressive Party government did that. And as I said, Burnham and Hoyt never went through any processes of sitting down and negotiating with people. People woke up one morning and they read in the newspapers or in the official gazette that the property was gone. And they were in it. Here, you have a transparent process. You have market value determined by the government valuation officer. And then because they were rejected, we went to the private sector and we got private sector valuation officers to give a value as well. The people who are opposed, they're not opposed to the process. They are not saying that they're not giving up the property. They're not saying, they're not complaining about the legality of the process. They want higher compensation. And guess who is the singular valuation officer in all the cases where the valuation is coming in exorbitantly high? David Patterson. And who is the lawyer representing the people? Roysdale Ford. It is part of a political attempt to sabotage the process. So we decided to go for possession in the court and for the court to determine the compensation. Now, as I said, right now as I speak, and for several months, the state owned those properties. And the state could have taken possession by force and throw everybody out. We didn't travel that road. And lodge compensation in the court. The state can do that. When we went to the court, we told the court, look, if there is a dispute in relation to compensation, we have no problem with that. But give us the possession because we need the possession now. And that is what the law allows. The law could never intends that the issue of compensation can delay a national project. What the law contemplates is that you deliver possession to the state and let the court determine compensation. You can go all the way to the Caribbean Court of Justice with the issue of compensation, but possession must be given to the state. Unfortunately, one judge ruled that compensation must be paid first. I respectfully say that that decision is wrong. It is a misapplication of the law, and it's a misinterpretation of the letter and spirit of the legislation. It's consensual. The law, because no one can question the state's power to take the land, all you can question is your compensation. Years ago, the state compulsorily acquired a plot of land on Water Street from Tulsi Prasad Limited to accommodate pavement vendors. Tulsi Prasad rejected the compensation, but the state took possession, and the compensation was determined by the court years after. And that is how it has always been. That is the law. Several properties along the West Bank and West Coast, which we have acquired, most of them were settled, but two, I believe, are in the court. But we got possession for the running of the pipeline. Because the law will not contemplate that the public purpose would be delayed over a squabble over compensation that can always be determined. And that is why the state is required to vest the title first into itself. So the decisions where the court has ruled that possession can be given until the compensation is worked out, those decisions will be appealed. Those decisions will be appealed because we feel that they are wrong in law. And you have cases right across the world that have determined this issue over and over again. It's not only Guyana, you have a delay because of a failure to agree on compensation. Obviously, you will have that. And the law makes provision for that. But that is an issue that is determined at a later date. But the state's project of national importance can't be delayed on that basis. So, and of course, here you have the politicians now that have contaminated the equation and are ill-advising the people. Because eventually, at the end of the day, they will get less than what the state is offering. One judge has already ruled that way. We were paying the people far more. And the lawyers advised them not to take the compensation. And now the people end up getting less. The people should sue the lawyers. But that's when you want to play politics with the law. However, we are pursuing this matter to the end, and the construction is not being delayed. We have to ensure that the construction is not delayed. As I said, the title for these properties are with the state. And if it is that the eventuality arises that the state has to use its coercive powers, well, then the state may have to resort to that as a matter of last resort. Because it's, I think, 4 persons. 4 persons will not stop the Demerara River Bridge from being constructed. 4 persons affecting a project that will help 800,000 people. At what level does that make sense? And what type of politician are you when you are sabotaging a project of that magnitude that will help your own supporters for some narrow political end? It's a sadistic mentality for one to possess. Time is flying. Please share the live, share the program so that your friends and your followers can join us in tonight's discussion. So, last week, I attended a Council of Legal Education meeting in Trinidad and Tobago, where the law school that we plan to build in Guyana was discussed. Let me just provide you with some background information. You will recall that Guyana has made a request at the Council of Legal Education to establish, for the council to establish one of the regional law schools in Guyana. Our position is that we will fund the construction and we will provide the land, we will fund the construction of the building, and the council will run and manage the law school in the same way that it is doing in Jamaica with Norman Manley Law School, Trinidad with Hugh Wooding Law School, and the Bahamas with the Eugene Dupuch Law School. The council had asked us to do a feasibility report to establish how such a venture is feasible. Government of Guyana established a committee to work on this matter. Yours truly is the chairman of that committee. I presented a draft feasibility report to the council at its meeting last week. Council was impressed with the report, the draft, the preliminary report. Council expressed its gratitude and congratulated Guyana for presenting an excellent preliminary report, and council appointed, upon my request, a high-level subcommittee of the council to work with Guyana on this project, on moving the project forward. And that subcommittee, of course, would be chaired by yours truly, and it includes Justice Lizelle Weeks, Senior Counsel, who is the chairperson of the Council of Legal Education. So let me repeat that name, Justice Lizelle Weeks, Senior Counsel, chairperson of the Council of Legal Education, and she's from Barbados. The Honorable Reginald Amor, Senior Counsel, Attorney General of Trinidad and Tobago. The Honorable Madam Justice Louise Blenman, Chief Justice of Belize. Miss Tonya Bastian Galanis, Principal of the Eugene Dupuch Law School in the Bahamas, and Jacqueline Samuels Brown Casey, a member of the council and a former chairperson of the Council of Legal Education. Government of Guyana will add another member of council to this committee, and that is Dr. Lloyd Barnett, a very respected and experienced Jamaican lawyer who has been part of the Council of Legal Education for nearly 4 or 5 decades. He has a wealth of experience and is highly respected as a lawyer and a jurist, not only at the level of the Council of Legal Education of the Caribbean, but across the region. This committee will be working with the Guyana Committee in moving the process of the establishment of a regional law school in Guyana forward. So a meeting will be held shortly, and we will keep you informed on the progress that is being made. I saw an article in the newspapers written by Senior Counsel Mr. Ralph Ramkaran, in which he's advocating for a scrapping of the constitutional reform process. That's an unfortunate statement from a gentleman of the caliber of Mr. Ramkaran, for whom I have high regard. I read the article, and there are a couple of things that I want to respond to. Mr. Ramkaran seemed to suggest that, as he understands it, we are going to review what was already reviewed in the 1999-2001 process. And if I get him clearly, that we would be second guessing that commission's work. And he's critical of that. Now, speaking for the People's Progressive Party, we made it very clear in a manifesto promise that we will launch constitutional reform, that our constitutional reform process will be driven by public consultations, and we will be reviewing the entirety of the Constitution, and based upon the public's input, that will influence what aspects of the Constitution will be reviewed. And we have said that repeatedly. So if it is that that involves reviewing the work already done, well, then so be it. That is what a constitutional reform process entails. Reviewing the Constitution and reforming it based upon the public consultations and the public recommendations which we receive. Mr. Ramkaran highlights a few areas that he feels should be focused upon. That is not what our approach is. We are not going to single out any area. We have made it repeatedly and excruciatingly clear that the public consultation will drive the review and the reform process. Mr. Ramkaran can come before the commission as a member of the public, and he can advocate what he would like to see reviewed. And obviously, as a member of the public and as a product of the public consultation, his recommendations and his views will be taken on board. But we are not going to accept recommendations from one individual writing in a newspaper. The constitutional reform process will outline a procedure by which we will receive recommendations and inputs from the public. And Mr. Ramkaran would be welcome to be part of that process. But we are not going to preemptively determine that we are going to look at issue X and issue Y, or provisions Y and provisions X. This is a public-driven process. The other point that Mr. Ramkaran makes is that he argues that no matter what we do to the 1980 Constitution, the people of Guyana will not accept it because it was born out of a rigged referendum. Now, that the 1980 Constitution was born out of a rigged referendum is a fact, which I do not dispute. However, we can't undo that. I can't unrig the referendum the same way that we can't unrig all the elections that were rigged in the country. Unfortunately, that rigged referendum is part and parcel of our history. Now, what have we done about it? Mr. Ramkaran himself led a constitutional reform process that made nearly 200 substantial changes to that constitution, which has made that constitution a radically different document from what it was in 1980. It is a radically different document from what it is or what it was in 1980. So agree with Mr. Ramkaran that we could never, I agree with him that we can't undo what was done in relation to the 1980 Constitution, the way it was birthed. You can't undo that. I don't know what he expects us to do. He was around in 1980. He was part of a process that was, he was with the PPP. They were the victims of a rigged process. You want us to undo that? So that part of the equation I didn't understand. But more changes are going to come from the process. And that's what is important. And as I said, Mr. Ramkaran can participate in the process. And I want to go back to an issue that we dealt with before. Because I saw Nigel Hughes making statements that to the effect that cyberspace must not be regulated. My friends, there is no way, that a space that billions of people, not millions, billions of people now use, can be without regulation and without laws. For anyone to argue such a concept, they are downright foolish. I don't know what else to say. We regulate land, and we have laws in relation to how you behave on land. Because billions of people occupy the earth. We have a large part of the planet Earth that is constituted by bodies of water, oceans and rivers. We have another set of laws governing that because millions of people use that and they occupy that and they do business on that waterway as well. Airspace, we have a whole bundle of laws that regulate airspace. In the same way, once you have cyberspace and you have billions of human beings who have access and are interacting, unless you want anarchy up there, you have to regulate it. And that's common sense. So all over the world, you have laws regulating cyberspace. You have books, textbooks called cyber law. Hundreds of textbooks. Every modern law enforcement agency in the world now have a cyberspace or a cybercrime unit. And you have people who are pretending to be national leaders are saying that we must not regulate cyberspace. Cyberspace is being used to commit offenses with the same frequency and offenses of the same seriousness as are being committed in physical space. You have identity theft. You have credit card fraud. You have fraud of different species. You have money laundering. You have terrorist financing. You have terrorism. You have pornography. You have trafficking in person. You have extortion. You have blackmail. You have murder. You can aid and abet murder on cyberspace. You can try encourage the overthrow of a government. You can commit treason in cyberspace. How will you not regulate that? What is illegal on land should be illegal in cyberspace as far as it's possible. And that should be the general principle. And that is why the United Nations has come up with a new convention to regulate cyberspace. And all of its members will adopt that. How can a leader of any quality argue against regulating cyberspace? As we have said, our laws are going to meet international standards. And that is why we didn't do anything before. I explained that our laws would be fashioned in accordance with similar legislation across the globe and in accordance with the international standards set by the international conventions. But it will not be anarchy in cyberspace. It will not be. Some persons have been asking me to give an update on the GTU case. As you know, we filed an appeal against the decision of Justice Sandil Kisoon, and we apply for a stay of one part of the judge's order, and that is the part which relates to the government continuing to deduct union dues from the teachers and transmitting it to the union. The judge ordered us to continue doing so, and we have appealed the entirety of his judgment, but we are asking the Court of Appeal to stay that aspect of his order, to grant a stay of execution. All the affidavits have been filed, and we filed an additional affidavit, and the case is before a single judge of the Court of Appeal. Tomorrow, arguments have begun, submissions have begun, and tomorrow, submissions will continue in that case. We said from the beginning that the strike was politically inspired. We said that the union members were meeting with the ministry continuously, and demands were being met, negotiations were being had, and the engagements continued. While that is taking place, another faction of the union calling for confrontational conduct, calling for strike. And we said that faction of the union was led by Coretta McDonald. That's a political faction. So when on the 29th of January 2024, the union leader and the vice president and so on met with the ministry, they thanked the ministry and they fixed a date. When they come out of the meeting, a letter was issued that there is a strike 4 days down the line on the 5th of February. That letter came from the other faction. Now, when you see at the end of the day, when an accord was arrived at between the union and the teachers, you see the same political element cutting down members of the union. You see that the union sold out, that the union leaders are in bed with the government, that the union leaders betrayed the teachers when the General Council of the union voted on the proposals. But that element in the union was always the political element. That element always was the political element. They were never concerned about the teacher's interest. And when the conflagration took place after the union leaders signed the agreement with the government, we put all of that before the Court of Appeal to show the court, well, this is the political side of the union that we were speaking about. This is the political instigation that we always felt was behind the strike action. So that case is ongoing in the Court of Appeal, and I will keep you abreast as the events unfold. As you know, we had a very, very successful public outreach program in region number 9 at Lethem, St. Ignatius, and Napi, where we conducted hundreds. This is an outreach by the Legal Affairs Ministry and Attorney General Chambers and the Deeds and Commercial Registry Authority. Several hundred transactions were concluded. And as I said, a branch or an office of the Deeds and Commercial Registry Authority will now be established in region number 9, so that that organization can offer the multiple services that it offers in Georgetown to the residents of Region 9. Region 9, Lethem is a town, and Region 9 is a very crucial region, and the people of that region requires the same services that the people of Georgetown requires. We have done this in Region 1. We are doing it in Region 9. The next region, I believe, we are moving to is Region 7, where we will do the same thing. So, Region 7, we are coming to you next, and we will do a similar outreach, and we will establish an office in that region. And this is an initiative of His Excellency President Dr. Mohammed Irfan Ali in the government's transformative efforts across our country. I want to thank you very much for the time that you have spent with me. I think we have covered great grounds and we have discussed some very important issues. Thank you very much, and join me next week as we continue our discourse. Thank you.